Is there anything more frustrating than being an officer on the witness stand in court and dealing with this?
Objection. Hearsay.
Well, rest assured, there is a way to demonstrate to the judge or justice of the peace at trial what it was that the defendant actually gave you as an answer to one of your questions during the investigation itself, but without actually reciting the words that the defendant used. And it is exactly this and more we'll be talking about. You'll definitely want to stick around. Court is in session. You are on the stand with me, Brian Lass. Roll the intro. And welcome once again. I, of course, am Brian Lass, and if you have not done so already, I will quickly send an invitation from here to there. Go ahead and click that subscribe button and bell notification icon below to make sure you are first in line to receive notification for videos just such as this directly to your inbox. So go ahead, take that 0.0001 seconds. You did it. It's done. Let's move on. And yes, many of us at one time or another, perhaps when we were just starting out, have been in that excruciatingly frustrating predicament of being at trial and trying to get out, hey, judge or justice of the peace, guess what? I asked the defendant a question and they gave me an answer. Here's what it is. And it is this very answer that led me to continue on in my investigation and ultimately charge the person. And that's why we're here in court. But again, as I've already alluded to, there absolutely is a way to do this without reciting exactly, the exact words that the defendant or accused person said. However, let's talk briefly about why it is that we cannot offer these words to begin with. And as an aside, and perhaps for a separate video, hearsay evidence, one of the most confusing, contrived rules of evidence, but certainly the brunt of hearsay unto itself on its face being that of 1, an out-of-court statement, and 2, being tendered for the truth of its content. So certainly now we're here in court. We want to provide an answer that the defendant or the accused gave us in regards to one of our questions. We want to rely upon this answer in court at trial unto its face value of being offered for the truth, which led us to act further and do whatever we did. But it's subject to any perhaps exclusionary rules of hearsay evidence, like the principled approach that we'll talk about in another video. And certainly in endeavoring to not want to have seemingly 8 million voir dires, a trial within a trial, to test the admissibility of this statement made out of court for that matter. Again, there is a very simple way, a templated way, if you will, to go about this. And I like to simply refer to it as the magic words. Yes, sound effects and all, we spare no expense here at the Brian Lass Show, but quite simply, what is that plug and play magical template, if you will? Well, let's bring up the PowerPoint and go through this. So although instantaneous, I know the anticipation was killing us all here, but yes, you can see on your screen absolutely the magic words or the magic template, if you will, and quite simply they go as follows. Your worship or your honor, I asked the defendant blank, so certainly we fill in that blank as applicable, and certainly defendant may be interchanged with accused depending if we're in a provincial offenses court or criminal court, but nevertheless we'll use our examples in a simple sort of provincial offenses context. So I asked the defendant blank, and based upon the defendant's answer, I was conclusively satisfied that blank. So again, certainly this is a way to alleviate or avoid reciting the actual words that the defendant gave to you in regards to whatever your question was, but still demonstrating that, based on this answer, you were satisfied with whatever it is they were offering. So let's use a couple examples and fill in those blanks, if you will. And again, still in this provincial offenses context, perhaps a simple trespass sort of related scenario here in the province of Ontario under the Trespass to Property Act. So here we can see we're in a stairwell at the original address of 123 Annie Street, and certainly we have these people seemingly hankering down, if you will, in the stairwell, and we're just going to go on the notion that the individual whose face is blanked out, the female, is our defendant here. So, another such example of filling in some of these blanks. This would be in the course, presumably, of an investigation for enter premise when entry prohibited. So, your worship or your honor, I asked Miss Smith. Now, our defendant's name here is Miss Smith, and just as an aside, I will say anytime you can use the person's actual name, that obviously humanizes the experience, takes away from the fact that this is just an entity known as a defendant or accused, but rather we acknowledge we were dealing with a person at the time. That is just an aside, take it for whatever it's worth. But nevertheless, I asked Miss Smith if she was a tenant at 123 Any Street. And based upon Miss Smith's answer, I was definitively satisfied. So here we use definitively instead of conclusively. I like to use the two words interchangeably. And based upon Miss Smith's answer, I was definitively satisfied that she was not a resident of 123 Any Street. Now, certainly, at this junction, if the Justice of the Peace or even defense inevitably wants to jump in and explore exactly what it was the defendant said, well, the door's wide open and obviously fill your boots. But here, this could have been either that the defendant said flat out, you know what, no, I don't reside here, or it could have been maybe the defendant said, hey, I'm here to visit Joe Blow in Unit 106, and conclusively because you're embedded throughout this specific community as a community patrol officer that there's no Joe Blow at Unit 106. So whatever the case is, you are still painting the picture that, you know what, I asked the question, I was given an answer, and based on this answer, I absolutely was satisfied that, the scenario here quite simply is that this individual was not a tenant at 123 Any Street, and certainly your investigation would go on as for such example. Now, another example, just to fill in the blanks here, another sort of variation, if you will. In this scenario, we asked the question, I asked Miss Smith what her purpose was for being in the stairwell at 123 Any Street, and based upon Miss Smith's answer, I was definitively satisfied that she intended to spend the night in the stairwell. And again, this answer, could have been in various forms or versions, if you will. Maybe it was as much as, you know what, I'm going to be honest with you. The back door was open. I came in here. And empathetically, of course, to anyone who doesn't feel comfortable staying in a shelter system, they decided they were going to hunker down here for the night. But again, whatever variation or form the answer came in, certainly based on the answer, guess what? You post a question, you received an answer, and based on that, you were definitively satisfied that she intended to spend the night in the stairwell. So, certainly this alluding to the fact of formulating your reasonable probable grounds for this respective trespass to Property Act offense. But, are we going to be so quick to just maybe lay a ticket or summons, or are we perhaps going to try to get this person some help, maybe seek some shelter for the night? Obviously, that's, your investigative considerations, your discretion, but these are such notions perhaps to be talked about in another video. Now, with all this having been said, and not so as to muddy the waters, but just as an FYI, should we, with this idea in mind of offering a question and answer and what we received as answer without reciting the words, if this now finds itself in the realm of an admission of guilt flat out, well, I will tell you that is for certain going to be of separate consideration, will plausibly go to a voir dire to test for voluntariness on reasonable probable grounds under the four-prong test it found in R v. Oikle, the Supreme Court of Canada decision. Now, that of course not to preclude if the defense actually waives voir dire, but nevertheless, just want to make sure we are making that distinction for the most fluid of experience for you in court. And quite simply, I'm sure the Crown and the respective learned counsel there will navigate those such waters accordingly. Now, as well as a further FYI, none of this from what we have talked about will preclude you from wanting to always make fulsome and diligent memo book notes in regards to this investigation that now finds itself in court with regards to literally what this defendant did say to you as an answer to their questions, because of course this will form a part of the disclosure package, and as well is something to be relied upon to support whatever sort of conclusion you are offering in trial on the record based upon the questions you had asked. And of course, absolutely, as alluded to, if the Justice of the Peace, the judge or defense wants to explore this a little bit more distinctively what the defendant said, well, the door is blown wide open and you can fill your boots and start reciting verbatim from your memo book notes. And with all this having been said, I certainly hope this was insightful. Of course, as always, I hugely appreciate all the positive feedback and engagement from this labor of love of sitting here making these videos in the sincere interest that it does assist any of you in any way, shape, or form. So with that being said, I wish you nothing but health, safety, and vigilance, and continued success moving forward. And we'll see you in the next video. Take care for now.